Two rules from kings and churches now close American courthouse doors to individuals who should have access. These two rules can take your property, they can take your freedom, and they could do this even when a court says you are right. Modern day judges treat these rules as if they always existed in America. In reality, they were imported decades after America's founding. They took one man's house, and they're still taking things today. I'll show you the story of how this happened and the two foreign words that American judges use to freeze you out of the courtroom. And I'll do all of this by simply telling you a few stories, with the first story being that of a man who had an inheritance taken away from him simply because a judge said one of those magic words, and with another judge pointing out not just how unjust it was, but even going so far as calling its use perverted. Washington, D.C., 1932. Lorenzo Allen inherited a house. He was still in high school when he did. He was a member of the school's cadet corps. His great-grandfather, Silas Holmes, had owned the home. When Holmes died, he left a will. The house would go to his daughter, Virginia. Virginia was Lorenzo's grandmother. She died in 1921. By then, Lorenzo's parent, Virginia's child, had already passed. Lorenzo was what remained, the sole surviving descendant. The house was his, but other relatives disagreed. They said the will only gave it to Virginia, and it didn't mean it would go to her grandchild. They went to court to claim the rent from the property. A judge sided with them. In 1925, he ruled the rent was no longer Lorenzo's. Lorenzo appealed. While that appeal was pending, the relatives sued again, this time for the house itself. They pointed to the first ruling and said the matter was already decided. The court agreed. Lorenzo was ejected from his great-grandfather's property. He didn't appeal that second decision. Why would he? The first case was still on appeal. That was the one that started everything. 2 years later, his appeal regarding the rent came back. He won. The appellate court said Lorenzo was right all along. Lorenzo was the heir, but he didn't have the house. The second ruling, the one that took the house from him, still stood. So he filed a new case to get it back. The relatives responded with a Latin phrase, res judicata, a matter adjudged, a thing already decided. The eviction was final, they said. Lorenzo hadn't appealed it. He couldn't raise the issue now. The trial court agreed. Lorenzo appealed. The appellate court reversed, called the situation unjust. The case went to the Supreme Court. 6 justices ruled against Lorenzo Allen. The eviction judgment stood, final and binding, even though the ruling it depended on had been reversed, even though a court said Lorenzo was the rightful heir. Justice Benjamin Cardozo dissented. He wrote that Lorenzo's eviction was the consequence and supplement of the erroneous adjudication that started everything. Lorenzo lost the house only because of a decree later proved wrong. Cardozo went further. A system of procedure is perverted from its proper function when it multiplies impediments to justice without the warrant of clear necessity. Lorenzo didn't lose because he was wrong. A court said he was right, but a higher court said it didn't matter. The earlier ruling came first. The doctrine demanded finality. He stayed ousted from the home. The Seventh Amendment guarantees a jury trial in civil cases over $20. Lorenzo's case involved a house and years of rent. He never got a jury. A doctrine about finality closed the door before he could reach one. Res judicata, a matter adjudged. The term is Latin, but another term, with its origin in the Old French used in medieval England, was making its presence known in America too. June 1974. Ann Hansen walks into a Social Security Administration office in Vermont. Her husband is dead. She has children to support. She wants to know if she qualifies for mother's insurance benefits, money Congress set aside for widows raising children. She meets with a Social Security field representative. His job is to help people like her. She asks, "Am I eligible?" The official tells her no. She leaves. But he was wrong. She was eligible. A year later, Hansen learns the truth. She files for benefits and starts receiving them, but she asked for the benefits she lost. The months she didn't receive because the Social Security official incorrectly told her she couldn't file the claim. The government rejects it. So she sues. The Second Circuit rules for Hansen. The government, the court holds, should be estopped, prevented from denying her benefits when its own employee caused her not to file. The government appeals. The Supreme Court reverses. Hansen loses. She doesn't get the benefits. The court's reasoning, Connolly's error did not cause respondent to take action or fail to take action. That respondent could not correct at any time. She could have filed anyway. She could have ignored the government's own representative. Justice Marshall dissented. I trust that the majority does not intend to suggest that a claim of estoppel is more likely to prevail when raised by a bank rather than by a person eligible for Social Security benefits. Ann Hansen was a widow with children. The law was written to help her. A government employee told her she had no claim. She believed him. The court held that estoppel did not apply. But what was estoppel? Wasn't this a question about benefits that she had a right to have? How does the definition of a foreign word mean the difference between a citizen getting benefits a law plainly states was designed to provide and not? Res judicata took Alonzo Allen's house. The definition of estoppel took away money a widow had a right to have. Res judicata and estoppel may have different languages as their origin, but their meaning comes from the same place, and we have to go back a few centuries to find it. Before there were federal courts, before there was a constitution, the Catholic Church had its own legal system, canon law. Church courts handled marriages, wills, disputes over oaths and contracts. Bishops or their appointed judges presided. They heard testimony, weighed evidence, issued decrees. No juries. The church stretched across Europe. It had courts in every diocese, and it faced a problem any institution with multiple courts face. What happens when someone loses in one court and tries again in another? The church needed finality. If a church is making a decision based on God's will, if you have two bishops disagreeing, well, that creates a problem. So canon law adopted a principle, res judicata, a matter adjudged. Once a court decided a dispute, that decision bound the parties. They couldn't bring the same case to a different bishop. The matter was closed. Bishops answered to Rome. The system needed consistency. But church courts weren't the only courts in England. The Crown had its own system, common law courts. The king's judges presided, and juries decided facts. Two systems, two structures. And when someone tried to use a church court ruling to block a case in the king's courts, the systems collided. That collision produced a trial that became the social event of 1776. Elizabeth Chudleigh was 22, a maid of honor to the Princess of Wales. She secretly married a naval officer named Augustus Hervey. The marriage stayed hidden so Elizabeth could keep her position at court. It failed quickly. Hervey went to sea. Elizabeth remained. Years passed. Eventually, she became the mistress of the Duke of Kingston, one of the wealthiest men in England. By 1768, both Elizabeth and Hervey wanted out. Hervey wanted a divorce. Elizabeth refused. An 18th century divorce required public proceedings, proof of adultery, an act of parliament. The scandal would destroy her. She found another way. She sued Hervey in the Bishop of London's court, a church court that handled marriage disputes. Her claim? Hervey was falsely boasting that they were married. She asked the court to make him stop. Hervey failed to produce proof. Elizabeth swore under oath she was unmarried. February 10th, 1769. The church court issued its sentence. Elizabeth Chudleigh was a spinster and free from all matrimonial contracts. Res judicata. A church court had spoken. The matter was adjudged. 3 weeks later, Elizabeth married the Duke. 4 years passed. The Duke died. His fortune went to Elizabeth, on the condition she remain a widow. The Duke's nephew had been cut out of the will. He wanted that fortune. In 1775, he brought criminal charges. Bigamy. Elizabeth was still married to Hervey when she married the Duke. The church court ruling was a fraud. Elizabeth would stand trial before the House of Lords. April 15th, 1776, Westminster Hall. Tickets sold on the black market for 20 guineas. 4,000 spectators packed the galleries. Royalty came from across Europe to watch. Elizabeth's defense was simple. The church court already decided this. She was ruled unmarried. Res judicata. The matter was adjudged. A secular court could not revisit what an ecclesiastical court had already settled. The prosecution responded. The church ruling was obtained by fraud. Both parties had colluded to hide the truth, and the Crown had not been a party to that original suit. April 22nd, 1776. The judges delivered their opinion. A church court's ruling binds only the parties before it. The crown was not a party. The king's courts were not bound by the bishop's decree. The House of Lords convicted Elizabeth Chudley of bigamy. Res judicata had limits. A church court's ruling could not automatically block a case in the king's courts. The doctrine stayed where it belonged, binding on the parties inside the system that created it, at least for now. But another word was rising in English law: estoppel. The greatest legal mind of 17th century England defined estoppel. Sir Edward Coke, Chief Justice of England. In 1628, Coke explained the doctrine. Estop cometh of the French word estoupe, from whence the English word stopped, and it is called an estoppel or conclusion, because a man's own act or acceptance stoppeth or closeth up his mouth to allege or plead the truth. Stoppeth up his mouth. He called it curious, and listed out the areas in which it was used, mainly dealing with deeds and land ownership. There's a reason why he found it curious, though. He only had part of the story. Estop is the original word, and it was French, but how it was originally used wasn't about stopping up one's mouth or stopping a case. It was about physics, blocking a stream, damming a road. You could see it in Britain, the legal treaties written around 1290. Estopper meant to obstruct, to plug, to seal up. It would not become a doctrine, a noun, a category, a portable tool for another 2 centuries. But first, we need to pivot back to that other term, res judicata, the one that took Lorenzo Allen's house. England, 1245. Pope Innocent IV excommunicated Holy Roman Emperor Frederick II. The conflict between church and crown was reaching across Europe. In England, King Henry III was fighting his own battles with Rome. Bishops demanded independence from royal courts. The crown demanded taxes from church lands. Disputes over property, over who controlled what, multiplied. The question that kept arising: when church and crown both claimed the same land, whose court decided? Henry de Bracton served as a judge on the king's bench from 1247 to 1257. He was also a clergyman, holding various church offices, ending as Chancellor of Exeter Cathedral, where he was buried in 1268. Around 1235, Bracton began writing something I can't pronounce, but it means On the Laws and Customs of England. The legal historian F.W. Maitland called it the crown and flower of English jurisprudence. But Bracton faced a common problem the common law could not solve. The Hessies Utrum put church and crown in direct conflict over the same land. 2 legal systems, 2 courts, 1 piece of property. And when a matter was decided in one system, what stopped the losing party from trying again in the other? The common law had no answer. It had no concept for finality of this kind, no doctrine that said this is decided permanently across jurisdictions. The church did. Ecclesiastical courts had inherited exceptio re judicatae from Roman law, a plea that the matter has already been judged. Once a court decides, the same parties cannot relitigate. The thing is decided. Bracton, priest, judge, scholar, knew both systems, and when he needed a tool to make royal determinations final against church challenges, he imported the church's own vocabulary to do it. The church could not object to the concept. It was theirs, and now it was being used to constrain the church and expand the royal court's power. King Henry VIII petitioned Pope Clement VII for an annulment. He had been married to Catherine of Aragon for nearly 20 years. She had given him a daughter. He wanted a son. The Pope refused. By 1529, Henry had removed Cardinal Wolsey as Lord Chancellor. By 1531, he had declared himself supreme head of the Church of England. By 1533, Parliament passed the Act in Restraint of Appeals, declaring this realm of England is an empire and forbidding all appeals to Rome. In 1534, the Act of Supremacy made it law. The king, not the Pope, held final authority over the English church. Church courts became the king's courts. Church property became the king's concern. And any legal tool that made royal determinations final, unreviewable, unchallengeable, served the crown's purposes. Somewhere in the middle of this transformation, a book appeared. Christopher St. Germain was a lawyer. In 1528, he published Doctor and Student in Latin. By 1530, an English translation circulated. The book was structured as a dialogue. A doctor of divinity trained in church law, explaining concepts to a student of common law. and vice versa. Translation was the method. Lost in translation was the effect. Later editions of the book discuss estoppels as a category, a noun, a doctrine, tools for creating finality, instead of just a regular word describing a blocking of a stream or road. But the earlier editions had something else, a word that looks similar, but is actually completely different. Espousal. Earlier editions contain passages about espousals, marriage, legitimacy, which son inherits. 2 words, 2 different meanings. But eventually the version with estoppels is the one that is cited and reprinted. It may have been early. It may have been after Coke made the term official in 1628. We don't know, but we do know the effect. Bracton had used exceptio re judicatae, the church's own Latin, to create a finality between king and church. The church could not object. The doctrine was theirs. Estoppel did the same work between king and subject, but in common language, words people already knew, stopped, blocked, sealed. The church was bound by Latin it invented. The people were bound by the English that they understood, which ironically was Old French, because Old French was the language used in courts during this time, a carryover from the Norman conquest. By 1628, Coke enshrined the stop-mouth metaphor as if it were the origin. He didn't mention estoppel's earliest use, or its resemblance to res judicata, or the seeming replacement of espousals with estoppels. He simply called the term curious. When estoppel crossed the Atlantic, American courts saw it as a doctrine of land, deeds, conveyances, property titles. In 1822, Chief Justice John Marshall defined it. The case was Blight's Lessee versus Rochester, a dispute over Kentucky land. The plaintiffs argued the defendant should be estopped from contesting their title. Marshall rejected the claim. The defendant has executed no deed to prevent him from averring and proving the truth of the case. No deed, no estoppel. Then Marshall explained what the doctrine actually did. If he is bound in law to admit a title which has no existence in reality, it is not on the doctrine of estoppel that he is bound. A title which has no existence in reality. Marshall understood. Estoppel forced a party to admit something that wasn't real, to accept a fiction as fact. But in 1822, the doctrine was constrained. Marshall brought it up only to say it didn't apply. A man who had never executed a deed could still tell the truth. 54 years later, estoppel would mean something else. Iowa, 1876. Samuel Cromwell held bonds from the county of Sac, Iowa. Not land, paper, promises to pay. The county had issued bonds to build a courthouse. The county now refused to pay the bonds back. Cromwell sued, but the county pointed to an earlier lawsuit. Cromwell had lost a case about certain interest payments. The county's argument, one loss ends everything. Cromwell was blocked, not by a deed, not by a sealed instrument, by a prior judgment that they called estoppel. The lower court agreed. Case dismissed. Cromwell appealed to the Supreme Court. Justice Stephen Field wrote the opinion. Cromwell won. Field held that losing on one claim didn't bar Cromwell from pursuing different claims. A judgment settles what was actually decided. Not everything that might have been raised, but something else happened. To make his distinction, Field reached to England, to a bigamy trial in the House of Lords, to the Duchess of Kingston, to res judicata, the church doctrine of finality. And he married it with estoppel. The doctrine, Field wrote, operates as an estoppel only as to those matters in issue or points controverted. Field used the doctrine to open a door. He let Cromwell through, but something had shifted. John Marshall had confined estoppel to deeds, to sealed instruments, to the formal machinery of land. Field untethered it. Now it operated in the realm of judgments, court decisions, and in the same decision, he introduced res judicata to American law as well. 2 words used by kings and churches, resulting in finality. One word shutting down claims the church brought against the crown to ensure that they were able to consolidate their taking of church lands, and the other shutting down claims subjects brought against the king. And these terms now were united in America, thanks to the Supreme Court and Justice Field. Finality's vocabulary was growing, and the Supreme Court made it so. The year Justice Field borrowed from the Duchess of Kingston, American courts already had what they needed: tools to handle unjust judgments, tools Congress had authorized, tools rooted in the common law the founders inherited. The Judiciary Act of 1789, the first law establishing federal courts, gave judges broad power. Section 14 authorized federal courts to issue all writs not specially provided for by statute, which may be necessary for the exercise of their respective jurisdictions, and agreeable to the principles and usages of law. All writs necessary, agreeable to the principles of law. And the common law provided specific remedies for situations exactly like Cromwell's and Lorenzo Allen's. There was a writ for when new evidence emerged after judgment, evidence that wasn't available before. There was a writ for when a court needed to correct its own fundamental errors. And behind these tools stood the Constitution itself. The Fifth Amendment, due process before the government could take liberty or property, a hearing on the merits. The Seventh Amendment, the right to a jury trial in civil cases over $20. Not a judge deciding everything, a jury. The founders knew about ecclesiastical courts. They knew about systems where bishops decided facts and no one had a right to a jury. But they built something different. Justice Field had all of this available, but he reached to England instead, to a bigamy trial, to a doctrine from courts that had no juries, no due process, no Seventh Amendment. It worked for Cromwell. Field used the foreign doctrine as a scalpel. He cut through the county's argument of Estoppel with res judicata. He let Cromwell pursue his claim. But doctrines don't stay where you put them. Res judicata was designed for finality. That was its nature, its purpose. And over the following decades, American courts stopped using it as Field had, as an escape hatch, but instead started using it as the way the bishops had, as a block, as a stop, as a door slammed shut. 56 years after Cromwell, Lorenzo Allen stood before the Supreme Court. He wasn't asking for a windfall. He was asking for his great-grandfather's house. A court had already ruled in his favor. The will language failed. Lorenzo was the heir. He had won on the merits. But there was that second judgment, the eviction. Lorenzo Allen lost his house. Justice Cardozo said the procedure that created that situation was perverted, the one that involved Estoppel. Lorenzo had the Constitution on his side. The Seventh Amendment guaranteed a jury trial. The Fifth Amendment guaranteed due process. The common law gave courts tools to correct fundamental errors, tools Congress preserved in the Judiciary Act of 1789. But none of that mattered. The court applied a doctrine from ecclesiastical courts, courts with no juries, no due process, no Seventh Amendment, to bar an American from his inheritance. Lorenzo Allen never got his house back. Two doctrines, two imports. Res judicata, born in church courts to keep bishops consistent across medieval Europe, and Estoppel, born in feudal England, tied to the king's seal, confined for centuries to deeds and land. Lord Coke, the top legal authority in England, looked at the doctrine and called it curious. Chief Justice Marshall kept it constrained. No deed, no Estoppel. Field untethered it, and he married it to res judicata. He expanded it from deeds to judgments. And once expanded, it kept growing. By 1932, res judicata had already taken Lorenzo Allen's house. Property a court said was rightfully his. In 1981, a court test for defining estoppel took away a widow's Social Security benefits. American courts had tools to prevent this. Writs to correct error, due process, jury trials. Tools designed to ensure that finality served justice rather than replaced it. Those tools sat unused. Instead, courts reached to England, to church law, to feudal custom, to doctrines designed for systems with different values and different structures. The Seventh Amendment promises a jury trial. The Fifth Amendment promises due process. But doctrines from foreign courts, imported, adopted, allowed to grow, can close the courthouse door before those promises mean anything. Foreign doctrines, American consequences. To learn about other quiet mechanisms that can and often do impact your life, and not always for the better, check out my Plain Meaning channel on YouTube for more episodes. And if you watch them all, don't worry, because I release a new one every Tuesday.